Hi friends, today's video you must watch very seriously as professionals. Whether you are chartered accountants, advocates or company secretaries dealing with tax practice. We've all heard, analyzed, understood the purpose, interpretation and meaning of Section 70 of CGST Act, giving powers to the proper officer to call anybody in connection with any inquiry in his own case or in someone else's case in connection with some matters of GST. Friends, last 2 months, I have experienced 3-4 cases in Delhi and Pune, especially CGST and DGGI, that they call you for statements and by the evening they arrest you. They do not follow any law. They don't wish to follow any law. And at this stage, whatever judgments you quote, they turn a deaf ear to those judgments. And you can't fight them. You can't argue with them because you can also be in trouble. The head of the departments are so biased that this is unbelievable that we are living in a free democracy. Section 70 is for the purpose of inquiry. There is no question of arresting people at this stage of inquiry. Of course, we know they need not pass an assessment order under Section 74 or 73 or 74A to arrest a taxpayer who may be registered or unregistered. In spite of Supreme Court judgments, including Radhika Agarwal and the latest yesterday of Sandesh Kumar, they do not care at all about any law. Why I am making this video and giving you these kind of very strange observations is that whenever your client or you come across a summon under Section 70, where some Section 74A or 74 inquiries are going on, involving an individual tax liability of 5 crore plus on valid, invalid, legal, illegal, ethical, unethical grounds, please do not send your client alone. Analyze the pros and cons, especially if there are high stake cases where 1 or 2 people who have planned all the bogus billing in their opinion, and you are one of the buyers, or they claim you are one of the suppliers. Then notwithstanding whether you are a supplier or a buyer, do not go under Section 70 till you first approach High Court of your jurisdiction and make a statement you will participate in all inquiries without any delay, without any problem. But you should be given a protection from Section 69, that is Section 132. Friends, the kind of grounds they mention is all normal. Bogus billing, no materials applied, fraudulent input tax credit, parties non-existence, parties RC cancelled or they cancelled, transactions are very heavy, transactions are not matching, and the addresses where they function were not available. So all kind of reasons are given, which are not a part of Section 74. 74 deals with 3 things: tax not given, short paid, or wrongful input tax credit taken. 74 deals with taken or given. They do not give these findings because they do not analyze your books of accounts at all. No doubt. Supreme Court says that for arrest under GST, the final determination of tax liability under Section 74 or 74A now is not required. Therefore, once your client is arrested, the kind of harassment that follows in this country is unimaginable. Not only the client's family is punished, there is a social stigma put on them for no rhyme or reason, maybe tomorrow they are acquitted, and most of them are acquitted. I have not seen any single person where a case has been carried through with GST and he has not got relief. But the local courts do not give bail. They simply remit you to judicial custody, say for a blank order of 14 days. So if you don't get bail within 14 days, it's bound to be extended because the court has to grant a bail. Therefore, make it a rule, if you are confronted with a summon under Section 74 and your own liability or your purchase liability in more than ITC of 5 crore plus, that the department claims is fraudulent for A, B, C, D reason, please take a call, advise your client, take a protection from High Court. We all know that once tax is determined, 10% tax has to be paid and appeal is filed, the remaining demand is stayed. But that is Section 107. It has no interplay with Section 69 and 132. Though few courts have held that when at 10% appeal can be heard, then why not take 10%? But now Supreme Court has made clear that no monetary conditions can be put to release a person on bail. Therefore, friends, be careful under Section 70. That is now it is being demonetized at all levels. I've just experienced 3-4 cases which are extremely sad in nature. And one man has done hundreds of crores of one firm, 2 companies have done hundreds of crores of bogus billing. They do not go into inquiries on that. But they say, since you were one of the buyers from them, your name appears there, so you suffer. It's like Epstein files. Your name comes, you are in trouble. So friends, I thought to warn you, all of you as professionals, that whenever you face these kind of situations, take a call. Advise your client to approach High Court under 41A IPC or 35 BNSS. And Radhika Agarwal says, bail can be approached, for bail you can approach High Court including anticipatory bail. God bless you.